Thank you everyone. And I am just going to focus on standardisation and the role that CR plays in that. And our learned Professor Martin started with, I believe it was going to be 3 points, but I think it turned into 4. So inevitably I'm going to make 5 points and we'll see how we go. So I'm going to start with, it's been touched on already, but education and training. So CR sets the global standard for education and training in ADR. We do this globally. Our qualifications are recognised globally, so we award post-nominals once you pass our training successfully and become a member, and that enables you to join many panels, be recognised by many arbitral institutions around the world. And the things that we look at is the knowledge, skills and attitude that you have if you are going to be a successfully practicing neutral, be it an arbitrator, a mediator, or in many jurisdictions an adjudicator. So I think the importance of standardising education and people having the confidence that if you pick a CR member, you will know that they've been trained to the sufficient level to enable them to do their job effectively is very important. The next area that for CR, which I think is something else that we look at on a global perspective, is we're a quasi-regulator, and this has already been touched on before. But if you are a member of CR, you've done our training, you then sign up to ethical standards and rules, and you're making a commitment that in your practice you will adopt those standards and rules, and in the event that you don't, people can raise concerns with the organisation and those concerns will be investigated. So this differentiates CR members from perhaps other practitioners who haven't taken on those ethical standards and those rules, but it also gives confidence to the to clients that the arbitrator or mediator or adjudicator is going to abide by those rules. I think we could probably spend quite a lot of time talking about ethics in arbitration, but again, it goes to this issue of confidence. The third point really is if you are a member of CR, you are part of a global and diverse community of dispute resolvers. That's certainly one of our aims. That enables you to share best practice. It enables you to join these sort of conferences where we're sharing knowledge, skills, which will ultimately improve your practice. So there's a real emphasis on learning from each other. There's an emphasis on looking at things that may be coming down the track which will impact on your practice, sharing those so that you're on the front foot in terms of your practice rather than unaware of changes which may impact on you. So that global community and that ability to share knowledge and information between ourselves, I think is key. The fourth area, again we've touched on this, is guidelines. And this falls into a number of things. So CR works with practitioners around the world and produces guidelines. Those guidelines are areas of best practice. So for example, we've just launched a technology and arbitration guideline. When just after the pandemic hit, we issued a guideline on how to conduct hearings virtually. And those guidelines can be followed and in a flexible but standardised way globally to again support best practice. We also, on occasions, embark on strategic litigation, so we may intervene in certain cases around the world, again to ensure that the outcome to those cases is informed and in the best interests of arbitral or mediation practice. So an example of that was the case of, you may have heard of the case of Halliburton and Chubb, which looked at the issue of conflict. That was something that we, CR, that intervened on. in order to, again, inform and ensure a good outcome for ADR. In terms of other things that we do, I mentioned in my speech earlier, we do have observer status at UCITRAL. So that observer status enables us to influence and put forward suggestions which will again impact on that standardisation approach that is taken to practice, and we do that on behalf of our members globally. And finally, I'm just going to touch on the issue of diversity. Again, it's been mentioned before, but we actively support diversity, enabling those to join CR, but also join the ADR profession, irrespective of their background. And I think it's important to all of us that we have an ADR community that is reflective of the society it's serving. So we actively intervene to support those from perhaps underrepresented or indeed disadvantaged backgrounds to join the profession. Just in terms of Pakistan, the question I've been asked is, what is the way forward for Pakistan? And I think there's so many opportunities for Pakistan. We've already touched on there is an opportunity from an international perspective to consider adopting the UCITRAL model law. I know that the 2011 Recognition of Enforcement Act was passed as a means of adopting the New York Convention standards, and I think there's certainly an opportunity there, and I know that that's been recognised by the Pakistan's Supreme Court in the case of Orient and SNGPL, where it was recognised that adopting the UCITRAL standard would be a definite advantage. There's no specific law for Pakistan for seated international arbitrations, and again I think there's perhaps an opportunity to look at that, and there's probably some legislative reform around the 1940 Act would be helpful. But I think the important thing to say in all of this is that Pakistan is pro-arbitration. It's good to see that the courts are regularly enforcing awards, and I think that sort of builds on this platform on which we're trying to launch today to really establish Pakistan as an international seat. And just as a final thought, there are some guidelines, some principles that CRB issues in terms of capacity building and working with countries which are looking to establish themselves as seats of international arbitration. And again, I'd encourage Pakistan to consider those as part of its arbitral journey as it changes its legislation and moves towards becoming a recognised and established seat for international arbitration. So thank you.